it's Shamian Ao here. In this week's video, I will share my high-level observations on Indonesia's proposed implementing regulations for its Personal Data Protection Law, or PDPL for short. On 31st of August, which was just last Thursday, Indonesia published for comment a set of draft implementing regulations for its PDPL. The consultation closes on the 14th of September, so just next week, and enforcement of the law is expected to be by October next year. The text of this regulation is very long, a whopping 188 pages in its machine-translated English version. So the requirements are also really prescriptive in certain parts, and notably more stringent than its neighboring equivalents in Southeast Asia and even beyond. I will highlight 4 such unique features of this regulation here. Number 1, a data subject who is a child is defined as someone who is under 18 years old and unmarried. This will have practical implications for organizations relying on consent to process data of persons within that age bracket, since they will need to ascertain their marital status as well. Number 2, agreements between a controller and a processor need to be in the Indonesian language. It looks like contracts involving processing in Indonesia will need to be localized and translated into Bahasa Indonesia, and a suitable conflict clause included to say that the Indonesian version will prevail in the event of any inconsistency. Number 3, data subject rights need to be acceded to within 72 hours. As drafted, this appears to be the case regardless of whether the request gets received by the organization on a public holiday. Number 4, in corporate M&A transactions or even dissolutions, the regulation imposes onerous obligations on the controller to notify data subjects of the relevant event. For instance, it seems that the parties involved in an M&A transaction will need to be treated as joint controllers and need to serve a prescriptive notice to the impacted data subjects, informing them of the transaction prior to completion. In a dissolution scenario, the company that is undergoing dissolution would need to appoint a DPO, that is another party or another contact person. Needless to say, it will be interesting to see if and how these provisions get revised and refined in the next iteration of the rules. If you need help in understanding the impact of this law on your business, do feel free to reach out.